नमस्कार, आदाब, सत श्री अकाल दोस्तों। स्वागत है आपका एक बार फिर से हमारे YouTube चैनल ब्रास फ्यूजन्स पर, जहां हम आपके लिए एक बार फिर से लेकर आए हैं एक नया लेसन।
Rejudicator. In the last class we have done res subjudice, that is dealt in section 10. Just a minute. Right. Now res subjudice is dealt in section 10. Now today what we're going to do is res judicator. Res judicator is dealt in section 11 of CPC. Let's start by reading this section and clause by clause I'll keep on explaining it as and when required. Right? Now section 10, if you remember, deals with what? Section 10 basically deals with the stay on the suit. If there is a suit which is already pending in a court and somebody wants to file another suit with respect to the same subject matter between the same parties and having the same title, then in that case, please, somebody's mic is on. Please switch it off. It's creating disturbance. Somebody's mic is on. I think Shriram, आपका mic on है. Please switch it off. Shriram, please switch off your mic. Okay, Abhinav, your mic is also on. Please switch it off. Abhinav Dwivedi, your mic is on. All of you, please switch off your mic. All right. Okay, fine. With a reading of section 11. Now, what does basically section 11 deals with? Section 11 tells you the principle of res judicata. Right? Now, what is the principle of res judicata? R-E-S, res, J-U-D-I, judi, C-A-T-A, kata, res judicata. What does this mean? This actually means the rule of conclusiveness of judgment. Which means what? If there is a court, it has already decided a particular matter that is in controversy. This decision has been given. Now, the decision is given on merits after hearing the parties and all that. Now, a party again goes to the court with the same cause of action. Now, this section 11 basically bars the jurisdiction of the court, that the court cannot, in such a case, try this matter again. So, what section 11 or res judicata principle is? Now, res judicata principle is that once a matter has been heard and finally decided by a court, the same matter cannot be taken to the court again for the trial. Right? This is what res judicata means. When I'm through with res judicata, section 11, I'll give you a difference between res subjudice, that is section 10, and res judicata. This will help you to appreciate the features of each of these provisions. Now, see, section 11 or res judicata, firstly, is the rule regarding the conclusiveness of a judgment. Now, conclusiveness of a judgment means what? Conclusiveness of a judgment means that once the court has given any decision, that decision is final and binding. As far as this level of court is concerned, you will always go in appeal. That is not a bar. But then as far as the court of same stature, same standing is concerned, that decision is conclusive and binding. That means you cannot go to the same court or a court of the same stature or the same standing and file a suit again. No, I did not like this judgment, so I'm going to court again. For example, you go to a civil judge of junior division and you file a case and a decision has been given against you and you're not satisfied. What is the relief with you? You can go in appeal. But instead of going in appeal, what you do is you file another suit. And in another suit, you are trying to, and obviously the same suit will go to the same court, which means a civil judge of junior division. Now you want the court to entertain this case afresh. Now that cannot happen. That's what res judicata bars. It said once the case has been decided, this decision is conclusive. As far as this court is concerned, you can go into appeal, but you cannot go to the same court and starting the matter afresh. Right? So this is basically, this is based on three principles. There are basically three principles on which it is based. Now, first principle is that no man should be vexed twice for the same cause, which means, let's say there was litigation which was going on between two parties. Now, the plaintiff has filed a suit against the defendant. When the plaintiff filed a suit against the defendant had to appear in the court and take care of all the proceedings. Now, again, what you want is, you want कि दोबारा से मैं same court में वो case file करूँ, दोबारा he should come and defend. So this is not justified, right? Secondly, it is based on the maxim, which is interest republica ut sit finis litium. Now, you will read any book or anything on this and you will find this maxim. I am trying to, I'm still learning how to work on Google Meet, so I'm trying to download this Blackboard and all that so that it will become easier for me to write. But for the time being, just hear me out, and as and when I'm able to learn to work on this Blackboard and all that, I'll start doing that. Okay. So for the time being, just listen to this maxim and you'll find it in any book on Rejudicator. It starts with the maxim. Interest republicae ut sit finis litium, which basically means interest of the state lies in bringing an end to litigation. ठीक है, which means the litigation should not go on and on and on. एक बार एक कोर्ट में केस डिसाइड हो गया, दूसरे कोर्ट, आप उसी कोर्ट में दोबारा जा रहे हो, फिर डिसीजन आ गया, उसी कोर्ट में दोबारा जा रहे हो. This is not in the interest of the state because it leads to wastage of time of the court, wastage of money, wastage of resources, and also putting the other party into trouble. So this is basically for the matter that there should be end to such litigation, right? Now, a third reason why we have this principle of conclusiveness of judgment is that judicial decision must be accepted as correct. Whatever judicial decision has been given, it must be respected. The judgment of the court has to be respected. So the main principle on which Rejudicator is based is on the principle that interest of the state lies in bringing end to litigation. It is in the interest of the state that there should be an end to the litigation. Litigation means the proceedings that are going on, right? So if the proceedings keeps on going on in the same matter again and again, it's a trouble. It's a menace, right? So we need to control it. So that is why we have the provision of Section 11. Now, let me read out Section 11 and I'll come to the ingredients one by one. Now, Section 11 says, no court shall try a suit or issue. Now, there are two things in which the trial, the competency of the court has been barred. Firstly, it cannot try a suit or it cannot even try an issue. If you remember Section 11 and Section 10 which is stay on the suit, it applies only to the suit. It does not apply to a issue. Whereas res judicata applies to two things. It applies to the entire suit and it also applies to a issue. How does it apply to an issue and all that? I'll give you an example and you'll understand. For the timing, just follow me. I'm just reading the section. So just follow me through. Okay. No court shall try any suit or an issue in which the matter directly and substantially in issue has been directly and substantially in issue in the former suit between the same parties. Now, this is more or less same as Section 10, that the matter which is in controversy in this suit was also a matter which was in controversy in the former suit, right? And third point is that these suits, both these suits, the former suit and the subsequent suit, both of them are between the same parties. So parties also have to be same, or under whom they or any of them claim, right? So it should be between the same parties or their legal representative or the people under whom they are claiming.
Your voice is breaking.
Now, litigating under the same title is again same as Section 10. The title of both the parties
Your voice is
have
breaking.
to be same. Right? In a court competent to try such subsequent suit or... My voice is breaking. Okay, just a moment. Just a moment. Just give me a moment. Alright, is it fine now? Is my voice fine now?
Yes, ma'am. Yes.
Himanshu Singh.
Yes,
tell
ma'am.
me.
Yes, ma'am.
Class, is my voice break? It's fine. Okay.
Yes.
All right. Now, see, third point, another point which has been dealt here is that the court has to be, the previous court should be competent to deal with the matter which is coming up in the subsequent suit, right? Now, the matter has to be heard and finally decided by such court. Now, this is extremely important point. And this is basically the heart and soul of Section 11, that the matter that we're talking about has to be heard and finally decided by the court. Right? Oh, Rahul, thank you. You have given the magazine. Thank you. Class, if you just look at the magazine, Rahul, you just posted on the... Okay, chat box. Okay. Now, this is what Section 11 is. Now, let me come to it ingredient by ingredient and every point by point. Now, what is Section 11 saying? Section 11 is saying that no court shall try any suit or issue. Right? Now, first thing that you need to remember is that Section 11 applies on suit also and issue also. Now, how issue? Let's say there was a suit in which the parties were A and B, and let's say it is a suit for Section 9, restitution of conjugal rights, right? Now, in this case, there were two issues. Firstly, the issue between the parties was that was there a valid marriage that was performed between the parties or not? Right? Second issue is the party entitled to the relief under Section 9, restitution of conjugal rights or not? Right? Now, between these same parties, in the decision, this case is heard and finally decided. All the issues have been dealt with in this case, right? So, court ने क्या decision दिया? Issue number 1 में court का decision था, yes, this is a valid marriage, right? Now, second case में दिया, okay, relief of Section 9 we are giving or not giving, that is immaterial for our case. So, court में decision हो गया, the case is finally decided. Now, what happens is, now there's another suit which is filed between the same parties in the same title, which means husband and wife के बीच में ही suit है, and their title is what? The title is not as husband, what is their legal capacity? As husband and wife. Now, there's another suit, and now the matter is something different. For example, the matter is, let's say, there's a bigamy का case. या फिर there is divorce का case, right? Now, in divorce का case, again the issue is, was there a valid marriage or not? क्योंकि valid marriage होगी तभी तो divorce होगा. या फिर अगर आप bigamy के लिए किसी को prosecute करते हो, तो you first have to prove that this marriage was a proper marriage, a marriage which was properly solemnized and all that, right? So, and the second issue is, should we grant divorce or not on the ground of cruelty, right? Now, in this case, the fact that the first issue, that is the marriage valid or not, has been heard and finally decided by a previous court in a previous suit, this will act as a res judicator, which means that this issue has been heard and finally decided. तो इस issue पे दोबारा proceedings करने की जरूरत नहीं है. The court, the party can say, okay, this issue has been decided, we need not refer to this issue, let's come to the second issue. Right? So this is what we mean when we say that res judicator applies to the whole suit also, and it applies to issues also. Class, clear about this?
No, ma'am, can you please repeat it again if possible?
This basically means कि अगर किसी केस में कोई issue decide हो रखा है, res judicator applies on the whole suit also and any issue also. If there is any issue, I told you, in a case there can be several issues, right? उनके लिए preliminary decree आती है, somebody is saying yes, preliminary decree is included. It is included. So if the preliminary decree has been given or a first issue has been decided by hearing the parties, और दूसरे केस में दूसरा केस जो फाइल हुआ है उसमें बहुत सारे इश्यूज हैं, लेकिन एक इशू वही है जो पीछे वाले केस में भी कॉमन था, तो कोर्ट उस इशू पे भी रेस जुडिकेटर लगा सकता है कि ये इशू तो ऑलरेडी डिसाइडेड है, इसमें हमें दोबारा जाने की जरूरत नहीं है और हम बाकी इश्यूज से वी विल डील विद. राइट? दैट्स व्हाट इट मीन्स.
Ma'am, is this matter is applicable to service cases also?
See, in what matter? In what respect? Give me illustration. Rejudicator
illustration
principle is
as-
applicable.
Illustration as in if suppose somebody has been dismissed from the service, and earlier the case has been decided by the High Court that he has been absorbed with the permission of High Court, but again the same issue, the court had dismissed that person on the same
No, the
thing.
court cannot do that. The court cannot do that. Once the court has heard and finally decided that his dismissal was wrong and he should be reinstated, again, if on the basis of the same misconduct, if on the basis of misconduct number 1, he was reinstated, saying that it is a false allegation and everything. Now, on the same misconduct, he cannot be again dismissed unless the matter is going in appeal, right? However, now if there is a new misconduct, he is doing misconduct number 2, right? Again, after being reinstated, he is indulging again in misconduct, corruption, or whatever. In that case, he can be, obviously it's a different matter altogether, a different suit altogether, a different cause of action altogether. So for that, it can be.
And ma'am, what is res judicata in CPC is double jeopardy in IPC?
Kind of. You can draw kind of parallels, yes. Kind of. But not exactly. We have punishment and all that, so that's not a case of punishment and all that. Double jeopardy basically gives relief to an individual that he will not be punished again for the same offense twice. That is dealt in Article 20 of the Constitution.
Yes.
However, Article 20 Clause 2. Alright. Now, however, here we are talking about a case where the court has been barred. The jurisdiction of the court has been stopped, that you cannot try this case again. It is a bar which is put in the power of the court. It is obviously for the convenience of parties and for the state and all that, but the restriction has been put on the power of the court here. Right?
Okay.
Alright. Now, coming to this thing, firstly, no court shall try any suit or issue in which, firstly, the matter must be directly and substantially in issue in both the suits. So the matter in controversy has to be same in both the suits. What is the second requirement? Second requirement is the parties should be same, right? So the parties have to be same, just like in Section 10 we did in res subjudice, the parties have to be same. Now, third is, such parties must have litigated under the same title. So that also is just same as in Section 10. They should be litigating under the same title. Then, fourth point. Now, what does fourth point say? Fourth point says, the court which determined the earlier suit must be competent to try the later suit. Right? Or the suit in which such issue has been subsequently raised. Which means what? If the court which has given the decision in the former suit, in which the case was basically heard and finally decided, now that court must be competent to try the second suit also. If the second suit would have gone in this court, then it would have been competent to decide, which means it should not be an appellant court, or it should not be a court which is of a higher jurisdiction, at a higher petition. It should be the court which is at same level, right? So that is when Rejudicator will apply. अगर आप एक केस से अपील कर रहे हैं, the decision has been given by lower court, a civil court, and you are making appeal to the district court, or from a district court you are making appeal to the high court. Then you cannot tell the high court, no, the district court has decided, so you have no jurisdiction. No, because this is an appeal that can be allowed. But if the court it has the same pedestrian, then in that case Rejudicator will apply. Fine, class? Okay. Now, a very, very important point that has to be there in Rejudicator is regarding the issue directly and substantially in issue in the subsequent suit should have been heard and finally decided in the earlier suit. Now, this is extremely, extremely important point that you have to keep in mind, and that is that res subjudice will only apply in cases where the suit has been finally disposed of. If you remember Section 10, in Section 10 I told you, Section 10 will apply in the cases where the matter is still pending. आपका केस एक जगह पे पेंडिंग है, दूसरी जगह पे कोई पार्टी सूट इंस्टीट्यूट करती है, तब वो कोर्ट स्टे लगा देगा कि एक जगह पे कोर्ट सूट ऑलरेडी पेंडिंग है, There is no need for us to, go into the second, file the same, try the same matter again. Lekin, res judicator basically deals with the matter that the suits are not pending. The suit has been heard and finally decided, which means the final decision has been given in this case. Final decision kaun se court ka? Final decision of the court at that level, not in appeal. Right? And this will become more clear when we do the these explanations. Class, any doubt till now? Then I'll go to the explanation, which will make these provisions even more clearer. Any doubt till now? Please ask.
Ma'am, can you give an example of substantial part in the second, this directly or substantially matter in the issue?
See, there are so many directly substantially issue means basically the main matter which is in controversy. There can be so many ancillary issues also when we decide any matter. तो वो ancillary issues से res judicata नहीं लगता है. लेकिन the matter which is directly in issue, which is directly in conflict between the parties, that would be a matter which would be directly and substantially in issues. उसको डिसाइड करने के लिए बहुत सारे एंसिलरी मैटर्स होते हैं, जैसे कि लिमिटेशन बार हुआ है या नहीं हुआ है, इज दिस कोर्ट हैविंग ज्यूरिसडिक्शन और नॉट. सो दीज आर ऑल द एंसिलरी एंड प्रिलिमिनरी काइंड ऑफ मैटर्स. उन पे रेस जुडिकेटा नहीं लगता है. राइट?
Okay, ma'am. Okay.
Ma'am, in the cases of maintenance, if the court had passed this maintenance to a lady, and if suppose
See, res
that lady...
judicata does not, Himanshu, I got your question. See, res judicata does not apply on interim release or interim orders or interlocutory orders. For example, if there is a issue of temporary injunction. So temporary injunctions means stay order. राइट या फिर एनी इंटरलोक्यूटरी ऑर्डर का एग्जांपल होता है मेंटेनेंस ऑर्डर विच हैज बीन गिवन. फॉर एग्जांपल लिटिगेशन इज गोइंग ऑन बिटवीन हस्बैंड एंड वाइफ रिगार्डिंग मेंटेनेंस, रिगार्डिंग अ डिवोर्स. In the meanwhile, the wife files an application for maintenance, right? The court grants, okay, maintenance granted. For till the suit is going on under Section 24 of Hindu Marriage Act, the court goes ahead and grants maintenance to the wife till the case is going on, right? This is a order which is not a heard and finally decided kind of order. It is a temporary relief which has been given. So it is an interlocutory order. It is a kind of a temporary relief.
दोस्तों, ब्रास फ्यूजन आशा करता है कि आपको हमारा लेसन पसंद आया होगा. कमेंट बॉक्स में अपना फीडबैक देना ना भूलें. थैंक्स फॉर वॉचिंग.